Hello and welcome. My name is Lynn Freer. I'm the president of Spidell Publishing, and I'm happy to be here today to tell you what we know and more what we don't know about the two Supreme Court decisions, Proposition 8 and the Defense of Marriage Act cases. The United States Supreme Court recently struck down a provision of the Defense of Marriage Act that denies federal benefit to legally married same-sex couples. The second decision had to do with Proposition 8, and the Hollingsworth versus Perry case was dismissed. It sought to enforce Prop 8, California's ban on same-sex marriage. So what we have now is a situation where same-sex married couples will be treated like opposite-sex married couples, and same-sex couples can marry in California. Now that's kind of what we know, but there's a lot more that we don't know, and that's what we're going to talk about here today. Recently, Kiplinger announced that same-sex couples could file amended returns, and we know that that's probably true. We have not, however, heard anything official from the IRS about how that's going to happen. In our presentation today, if you have not already, you may want to download and print the PDF file that we sent with this, which has the information that we're going to be talking about written down. The Hollingsworth case, the Proposition 8 case, counties are now performing same-sex marriages again. However, the Prop 8 proponents have asked the Supreme Court to stop the marriages. We don't think that that's going to happen. Now, this does not create problems for us for prior years because these folks weren't married prior to 2013. However, when you're doing tax planning, projections, estimated payments, withholding, etc., for this current year for those folks, you'll want to do the same thing that you've always done for married couples, and that's to consider what the tax liability is going to be jointly. The next case, which is the one that has a lot more for us to look at, is the Windsor case. And in the Windsor case, a district court in New York found that the Defense of Marriage Act was unconstitutional as it applies to estate tax law. The court in Windsor found that a surviving same-sex spouse was entitled to a refund of estate tax on her deceased spouse's estate. The Supreme Court affirmed this decision, and while it will certainly affect your same-sex married couple in many ways, we're not sure exactly how the IRS is going to handle this. We do have a full text of both of these decisions at the end of the material here today. Let's talk about what the Windsor decision means, though. First of all, we don't know what the effective date is. The case involved a refund of estate tax paid, but it doesn't direct the IRS to accept amended returns for prior years. So we don't know whether the effective date of this ruling is the date of the case. If it's for all open years, we just don't know. One of the big issues involves employee benefit. When does an employee pension plan or an employee benefit plan have to be amended? We don't know if they need to be amended immediately or if they can use snap-on language. In other words, just an addendum to the current plan and have a complete plan amendment in 2014. We've talked to Spidell's pension plan folks, and they say that the lawyers are still discussing this. So this, again, is something that we don't know yet. The next thing we don't know is who must file as married. Is retroactive filing elective? In other words, if I file an amended return and get a refund, that's fine. What if I owe money? Do I still have to file an amended return? And remember, if I am going to file an amended return, I can still file them as married filing separately. They don't have to file jointly. However, when I amend that, the married filing separate rates and rules will apply. So in most cases, by going from single to married filing separately, they're going to be an additional tax assessed. What about registered domestic partners? In California, we have a number of RDPs, probably many more RDPs than we have same-sex married couples. Are they treated the same? California law says that RDP couples are to be treated as married in every respect. But does that translate to federal? Again, we really don't know. The other problem is, what about conflicting state laws? What if the couple lived in the state where same-sex marriages were legal, but now are living and domiciled in a state that does not recognize same-sex marriages or that didn't recognize them in the year that they were actually married? We don't know how that works either. We have a chart on the states that recognize same-sex marriage and the date that they were first recognized. California, of course, recognized same-sex marriage June 16th to November 4th, 2008. For the '08 year, for income tax purposes, most of the time that statute's going to be closed, so it's not going to make a difference. However, the '09, 10, 11, and 12 may or may not still be open. The '09, depending on when it was filed, may or may not be open. 10, 11, and 12, statute of limitations is still open, and those folks who were married during that period are still considered married. Other states that recognize same-sex marriage are Connecticut, Delaware, District of Columbia, Iowa, Maine, Massachusetts, Maryland, Minnesota, New Hampshire, New York, Rhode Island, Vermont, and Washington. We also now have some implications of the Windsor case and what's going to happen when our same-sex couples start filing jointly. The same thing that happens to opposite-sex couples that file jointly. It benefits some folks. For folks where both people are working or have income, then it may end up with an increase in tax because of the marriage penalty. So some of the things we need to look at is they're going to file as married rather than single. Going to use the marriage rates, standard deductions, marriage penalties. It's clear that they'll file as married. We just don't have guidance at this time from the IRS as to what year we're going to start. Also, we have tax-free employer coverage for the same-sex spouse for insurance, for health insurance purposes. In California, we've always treated an RDP or a same-sex married person the same as a married taxpayer for purposes of employer health insurance. So if the employer is paying the health insurance, the federal side, if the RDP or the same-sex married person was not a dependent, then that cost of coverage would have been included as wages. So there shouldn't be in California any change in insurance coverage, as insurance companies have been required to offer the same coverage to same-sex or RDP couples as they do to opposite-sex married couples. However, for federal purposes, there has been a wage difference, and that will go away. The requirement also is going to include same-sex spouses and employer cafeteria plans, like medical reimbursement plans, child care plans. It would be a big difference there. In the IRA area, we're going to see a difference in the distribution rules, and also, can I have a spousal IRA? That's going to be a big change. So if I have a working and non-working person, the same-sex married couple can set up a spousal IRA for the non-working individual as well, just like we've been doing for married couples. In the ERISA area, the pension plans are going to have to be updated, and rules regarding beneficiary designations and payouts will change. You may or may not be aware that if I have a qualified plan and a participant is married, the spouse must sign and designate that they agree not to be the successor beneficiary, not to be the beneficiary. So if I don't want to leave my pension to my spouse, I've got to get them to agree. The same thing will happen for same-sex married couples. Again, we just don't know when. Also, the deductibility and taxability of alimony when a same-sex couple divorces. That will be the same as for opposite-sex married couples. Property settlements, there will no longer be a taxable event when I transfer property between one spouse and another. So that's going to be another big change, and you may have amended returns where there were gift tax involved. Innocent spouse protections will be transferred to include the opposite sex or the same-sex married couple, and the gifting and estate tax benefits will also apply here. There will be no tax on gifts to spouses, like I said earlier, and the spousal estate tax exemption and the portability election will be available to same-sex couples. A big issue that we've been dealing with for a number of years is the IRS's position that the self-employed individual would split their earnings and each of the individuals would pay the self-employment tax on their community share. For an opposite-sex couple, the code specifies that the person who is working and earning the money is the one who must pay self-employment tax. That's basically how we read Social Security law, and we disagreed with the IRS on this. Well, this is going to go away because now I'm going to always treat them like a married couple of the opposite sex, and I'm going to report the income using community property on the two separate returns. However, the spouse who earns the income will pay the self-employment tax and get that deduction. When you're filing amended returns, be sure that you include that adjustment and create new SE forms, or a new SE form depending on what's going on, and keep a copy of that return. Check against the Social Security records to make sure that in a year or two that adjustment shows up. Because when you go in to collect Social Security, you want to make sure that the earnings are the maximum amount, and the best way to do this is to have that amended self-employment tax form to take to Social Security Administration and get that fixed if it doesn't get taken care of. We also have a $500,000 sale of residence exclusion that's going to be available even if only one spouse is on title. I'm, of course, going to use joint adjusted gross income to compute phaseouts and other adjustments, and many of our clients are not going to be in the category of saving money by filing as married, filing a joint return because of the marriage penalty. They'll be the unfortunate recipients of that penalty with this new law. So, of course, we're saying, yes, you should file an amended return, particularly file a return to protect the statute from expiring. The 09 statute ended on April 15th of 2013. However, if you filed an extension for 09, you would have 3 years. I say 4. In California, it's 4 years. For federal purposes, you have 3 years from the due date of filing the return if it was a timely filed return. So if you filed your 09 return on October 10th, let's just say, of 2010, you would have until October 10th to file a protective claim for refund. We would absolutely suggest that you do that. The other years, you can do it now or you can wait. Depends on what you want to do. But we do think you should file an amended return. Now, what about the California return? Do I have to file a California return? Probably not. Probably not for California purposes. If I'm filing married filing joint for federal, I must, under most circumstances, file jointly for California. But I've already filed jointly because California has required me for many years to file as a married taxpayer if I'm a same-sex married couple or if I'm an RDP couple. However, there may be a situation if I have the self-employed health insurance situation where it would change my tax liability by reporting the SE tax. If I divided it between the two of them, it may be different now that I'm going to report it all on one return. So in that case, I would also be filing an amended California return. Now, we've included a client letter here for you that you can send your clients. You can download the Word version and print it on your own letterhead. We don't suggest that you include all of our copyright information in your letter because you want the client to call you, not us. And I say this because it's not been uncommon for some of our tax professional subscribers to use the client letters and leave our name on them, and then they call us. Well, we at Spidell can do a lot of things for you. We can't help your clients file amended returns. We want to leave that up to you. When will we have answers? Well, we just don't know. Hopefully soon. The President has directed the Attorney General to deal with these issues. We're hoping that we'll have some answers sometime later on this summer. We're going to have summer seminars. We'll be starting on Tuesday, July 9th in San Jose. There are 8 of them, and the last one is on July 18th in Culver City. Renee Rada, who is our Vice President at Spidell, and you've probably seen her at our seminars, she will be talking about this along with her discussion of divorce tax. I'll be available to answer any other questions, but this is pretty much what we know here. We will also include updates in Spidell's California Tax Letter. That's our monthly publication on California taxes. And we will have a webinar when we have the answers. We have something planned. We're looking for sometime toward the end of September. So you'll have enough time before you actually have to file the 2012 tax returns on October 15th if you want to wait until then. But we will not do this until we get, some really definitive answers for you. And that's how we're going to handle it. We also will send out flash emails to those subscribers on our flash email list and to our customers, and we'll certainly be talking about this at our fall tax update. Finally, I wanted to show you my new grandchild because we're a family company here at Spidell, and this is my new granddaughter who was born last Saturday. So I just wanted to let you all be the first to see her, and I'd like to thank you all for your attention. I hope you had a wonderful 4th of July holiday and a successful summer getting those extended returns filed, except those for same-sex married couples. Just a reminder, there is also a link to the material just below the description in the YouTube video. Good luck and thank you very much.